Hi, I'm Carl Pearson. I'm an attorney, and this is video number 121, which I have entitled, Should I Accept an Offered Loan Modification Agreement? For the past 6 years, I've been going into court to stop foreclosures and to reverse or vacate foreclosure sales. For those of you who do not understand what's happening, I want it to be very clear that the way for the mortgagor to win in this distressing situation is by getting a loan modification agreement. In a foreclosure action, acceptance of an offered loan modification agreement would end the lawsuit, whether or not the bank shows you or your attorney the original note. In non-judicial states, this would end your default and it would start you off with a new note, and this is whether or not the bank shows you or your attorney the original note. I'm making this video because of a recurrent problem among homeowner-mortgagors. The problem is that they often do not like the terms of the offered loan modification agreement, if they even get one, and refuse to accept the terms. They tell their attorneys, if represented or if operating pro se without an attorney, they doing it directly, that the offered loan modification is unacceptable. I want to tell you what the consequences are when an offered loan modification agreement is rejected. First of all, let's talk about rejection during an ongoing mortgage foreclosure action. Rejection of the offer means that the litigation will continue, but in many states, such as New York, where foreclosure actions begin with negotiations or conversing to try to find a way to keep the mortgagor in his or her home, the focus of the foreclosure action will convert from the low-cost, low legal fees conferencing or mediation into a litigation mode, where the cost of defending the homeowner-mortgagor will jump to at least an additional $5,000 to $10,000 or more when preparing papers in opposition to the expected motion for summary judgment or for a judgment of foreclosure and sale. In other words, by rejecting a proposed loan modification agreement, the homeowner is thrown into costly litigation, but more importantly, the homeowner-mortgagor comes dangerously close to losing his or her home. When the summary judgment motion is made, all the judge has to do is grant the motion in spite of your opposition, assuming you had actually put in a timely answer to the foreclosure action, which most homeowners fail to do, by the way, and that is a disaster for them. Or grant the unopposed default summary judgment motion, granting an order for the bank to sell your property at public auction during the next 30 or 60 days or so. It could be more or less, and it depends on the state and even in the individual action. Accordingly, when you tell your attorney that you are rejecting the offered loan modification agreement, you are also telling your attorney, without any awareness by you possibly, that you are probably going to lose your home through auction sale within the next 30 or 60 days or so, once again depending upon state and individual county practices. I'm sure that most homeowners, mortgagors are not really aware of what they are doing and what happens when they reject a proposed loan modification agreement. The bank is under no obligation usually to come back with any other offer, and once you reject an offer, you cannot unilaterally reinstate the offer upon your reconsideration. The rule of law is that an offer that's rejected cannot be revived by the person that rejects it. So when you have a loan modification offer, you should consider it your final offer, and from a business standpoint decide whether you can afford to remain in the property, especially if the property is severely underwater and your payments will not be creating any equity in the property for you for a good many years. You might want to consider taking the offer even though it is unacceptable financially, and get your children through their present schools before defaulting once again and then leaving the property. You have to understand the consequences of rejecting a loan modification proposal. It is not your attorney's fault that the bank is offering what it offers, and you have to consider the offer from various standpoints to see if you should accept it or reject it. Don't reject an offer unless you have thought out the consequences of your rejection. Having said this, let me embellish a little bit. If you reject an offer and go into litigation and spend the additional money, you might, depending on the strength of your case, such as showing the bank has no note or has defective assignments of mortgage or note, be able to encourage the bank to rethink its loan modification offer and give you a better offer. This is a possibility, but there is the attendant risk. You may not get this at all, and you may lose your home as a result. You should talk about this with your attorney to see the strength of your case and for you to make an informed decision on whether you want to take that shot or not. As to the non-judicial states, if you reject a loan modification proposal, the bank will be able to get the trustee of the deed to put up your home for public auction without having to go through any significant judicial proceedings. This varies from state to state, but the result will be the same. If you reject a proposed loan modification, don't expect another, although it could happen, but expect instead to have your property put up for auction sale, followed by an eviction proceeding by the new owner of your property. A little embellishment here is if this occurs, you would go into court with an order to show cause, and if you have any strength to your case, it might then induce the bank to try to settle the case by giving you a loan modification agreement that's affordable and acceptable to you. That's only a possibility. You can never count on this, ever. I hope this clarifies what can happen when a homeowner-mortgagor rejects an offered loan modification agreement. Make sure you understand what the consequences are before doing any rejection. The bank doesn't have to come back, and usually does not come back, with any additional proposals. There's one more thing you should know, which is that when you apply for a loan modification agreement, you have a much better chance of obtaining a proposal when you use a highly experienced loan modification preparer. Recent rules of the Federal Trade Commission and state laws have prohibited many good loan modification preparers from providing their services because they're not allowed to charge for their services in advance of actually obtaining a loan mod proposal. As a result, many poor or inexperienced loan mod preparers lost their customers in business, but many good ones were also put out of business, making it more difficult for homeowners-mortgagors to obtain the help they need. They should not be doing loan modification applications themselves because it is difficult, with a lot of things to know, such as programs for HAMP 1, HAMP 2, HARP 1, HARP 2, hundreds of in-house programs, Fannie Mae, Freddie Mac restrictions, PNV or present net value analysis, restrictions of the various major loan services, differences as to investment and non-investment properties, just to name some of the issues that the loan modification preparer should be familiar with to provide the greatest amount of help to the homeowner-mortgagor, and quite importantly, having and knowing how to use loan modification software. Also, an experienced loan modification preparer will have various ways in which to encourage the bank or servicer to give a loan modification agreement when they really don't want to do so, including direct telephone calls to specified persons and government agencies and written complaints directed to the right person. If you want to discuss your matter, please give me a call at 212-307-4444. Thank you.